This is our third event in the legal track section of Dallas Startup Week. It has been a great day so far, and I'm very excited for this session and for our next session. I'm going to let Aaron introduce himself, but I want to thank Aaron so much for being a part of this. He graciously volunteered his time, and I really am excited to have him teach all this stuff. I know he's put a lot of work into this presentation, and I literally want to take up no more of his time because we only have 30 minutes and he has an excessive amount of stuff to cover. So with that being said, thank you, Aaron. I will let you introduce yourself, and I will be here the entire time to kind of coordinate questions if you need me. So if you need something from me, just be like, Jessica, I will be watching, but I'll be on mute as to not interrupt you. So thank you so much, Aaron.
Here's the first question. Can we all hear me? Okay, we can all hear me. This is great. All right, so my name is Aaron Cartwright. I am a business, construction, and securities litigator in Dallas, Texas. So I do all of the fun fighting in court, which is why I get to add a little bit of extra sauce to this presentation. Jessica does the wonderful stuff with the helping of setting up the business and those wonderful contracts and making sure that everything is exactly where it needs to be to make sure that you're protected. I'm the one that ends up actually duking it out and making sure that those protections are as effective as they're supposed to be. So with that, let's move into the presentation itself. All right, double click on the presentation that I have here. You don't need to see me, it's just me with a beard. Nothing's gonna change in the next couple of minutes here, but let's move forward, shall we? All right, so today we're gonna be talking about three different things really. That would be formation from my perspective, agreements from my perspective, and funding from my perspective. All right, these are kind of the core concepts, the most basic parts of the business that need to be worried about and considered kind of upfront. All right, so let's go straight into the formation here. All right, so a lot of the questions that I get at the beginning, Jessica can probably say the same thing, is we get a lot of questions about, well, what type of entity structure should I have? And the answer to that question is, of course, the one that everybody loves to hear. It depends. All right, so you've got several different types of entities in Texas. You've got your sole proprietorships, which isn't really an entity. You've got partnerships, both general partnership and a limited partnership. You've got your limited liability companies. It says corporations on there, and I'm not changing it. And you've got your for-profit corporations, you know, your S Corp, C Corps, which are actually IRS tax designations, and your nonprofit corporations. All right, so on the right-hand side, you'll see the costs, and we won't go too far into those, but what the vast majority of them, so from not general partnerships, from limited liability companies, S Corps and C Corps, and nonprofit corporation, those are what offer you some form of liability protection, okay? So the first two, general partnerships and sole proprietorships, they offer you exactly nothing at all right? Now, let me see here. Okay, let's go back really quick. Okay, so I'm not doing this on two screens, otherwise I'd be a little bit more fluent in this. So whenever you do your filing, basically, there's just a two-page form from the Secretary of State. You pick up your two-page form. A lot of the times you can file it online through a service called SOS Direct, or you can print it out, fill everything out, and send the Secretary of State a check with a check made out to the proper, or a check made out in the proper amount to the Secretary of State's office. All right. And whenever you do that, you'll just get your documents back. You need to send them at least 2 copies so that you can get a file stamped copy back. All right. You can pay with your card on SOS Direct. All right. Well, what was I going to say? There are services, LegalZoom, you know, your neighborhood friendly lawyer that can do this for you for an additional fee, but it's really not super difficult. Quick and easy form. Make sure that you've got your registered agent available. Your registered agent is someone that has to be over the age of 18 years old. They should be, but don't have to be in one location between the hours of 8 a.m. and 5 p.m. Monday through Friday, business hours, just in case, you know, you're served with a lawsuit. Really, that's the only purpose that they exist. Also, comptroller male, but we won't worry about that one. Okay, but as you can see on the right-hand side, those are the prices. All right, taxation. Sole proprietorships, general partnerships, limited partnerships, LLCs, and S-corps all default to what is called pass-through taxation. Okay, pass-through taxation, and I am not a tax guy. I know just enough to get me in trouble and you in jail. But pass-through taxation is the default for several of those. All right. What that means is that you will file your taxes, you will file your income and expenses on your personal tax return. So you will pay that at whatever your personal income tax bracket is, and the income may bump you up a tax bracket, or your losses may drop you down a tax bracket. That's for your tax person to say. But what that means is that you will be taxed on your personal tax return. Now, LLCs can opt to have what is called corporate taxation or C Corp taxation. All right. And what this is what is commonly referred to as double taxation. All right. And the reason it's called double taxation is because you are taxed twice. The first time at the entity level and the second time on your personal income tax. Let me explain that one. By the way, I'm going a little bit fast. We are very limited on time, and I want to make sure that I've got time for questions. All right. So let's say that your company brings in $1,500 worth of revenue in a year. All right. Well, whenever you bring that income in, let's say that it costs you $500 in goods and services. Let's say that you're a baker and you're spending $500 on eggs, flour, and milk. Okay. So you have that money goes out as part of your costs. Well, then you pay yourself as an employee $300. Okay, so you've got $500 that's going out in cost of goods sold, and you've got the $300 that's going out in salaries. That leaves you with a total of $700 left over in the business. All right. With C Corp taxation or with corporate taxation, the double taxation, you are taxed the first time on the amount of money you have left over. Basically, $1,500 minus $500 minus $300. So you're taxed on that $700 worth of income. Okay, that's the business level. Then you, as an individual, are getting I love it. Thank you, Amber Yorman. Then you, as an individual, are getting that $300 as a salary. Well, the government will tax you again on your $300 as a salary separate from your business. Now, if this was one of the pass-through entities, basically you report $1,500 in income, and then you would subtract $500 in cost of goods sold. Obviously, your salary, the rest of the money is what's left. Now, here's where my expertise kind of stops. Talk to your tax person about exactly what it is that you can and can't write off. I'm not giving you tax advice, but this is just to let you guys know how the different entities are taxed. All right. Liability. Liability is one of my most fun ones. Okay. Liability for me looks a little bit different than it does for the average business owner, let's just say. And the reason is people say, well, how can I best protect myself? Number one, you can hire Jessica Vittorio to make sure that your contract and the rest of your business is taken care of. Number two,
pay him to say that. I would like I did not pay him.
She didn't, but if you ask me, I'm going to endorse her all day. I literally send transactional stuff to her. It's fine. She's great. But when people ask me, how can I protect myself with, an entity structure? The answer is pick any entity that you have to pay money for in the state of Texas to register. Okay. When you go through a sole proprietorship or when you create a sole proprietorship, basically, I can just wake up in the morning and decide, okay, well, I'm in this business now. I'm going to go out and I'm going to bake cookies and I'm going to go sell them. Well, there's nothing stopping me from doing that. But if somebody gets sick from one of my cookies, they are going to sue me. There is no entity whatsoever in between that lawsuit and me personally. Same thing with the general partnership. If two people decide that together they're going to go out and sell cookies, one's going to bake, one's going to sell, and they enter into, a loose general partnership, or they just decide that that's what they're going to do, and they move forward with that, well, if somebody gets sick and decides to sue them, both of them are liable. Like, there is no entity whatsoever that will stop that. And I will actually explain that one here in a second after this next part. So when you actually pay the money to the state to get yourself a nice limited partnership, an LLC, a for-profit corporation, or a nonprofit corporation, liability breaks at the entity level unless you commit a direct tort, aka if you just bought a bad set of milk from your distributor and put that in your cookies, and then your cookies went and made somebody sick, that was a complete accident. Yes, your company may be liable, but your own personal assets are not up for grabs in a lawsuit. All right. However, if you pick up some rat poison and put that in your cookies and then sell those, then you are personally liable. That is an intentional tort. Okay. So the business doesn't stop intentional torts. So as long as you're doing good business, you shouldn't be liable in your personal capacity. I, as a litigator, have had the joyful and most wonderful, yes, please do not. But I, as a litigator, actually thoroughly enjoy litigating business matters, because what will happen is somebody on the other side will decide that they want to list everybody in the lawsuit all the way up the chain. They want to list the company, they want to list the employees, they want to list the founders, right? Well, if it's something that was done in the ordinary course of business and wasn't on purpose, I get to sit there and I get to file an affirmative defense of lack of capacity. And what that means is at the very beginning of the lawsuit, I get to have you removed from it personally. And that leaves the burden of liability on the company. But the company, as you all may know, you can pick up and walk away from. You can put it down and you can say, guess what? I'm done with this LLC. You can have everything that's in it. Your judgment is against the LLC. Take whatever's in there. I'm going over here. You can do this. I have done it before. It makes me happy and makes opposing counsel mad. But that's what they get for not paying attention. All right, so the steps that you need, can I give a simple definition of torts for the people? Yes, roughly. Okay, so a tort is something that would cause direct harm to a person or property. The most common torts you will find are assault and battery. So if I pick up a baseball bat and hit somebody's car with it, okay, now I've intentionally damaged their vehicle. If I'm getting in a fight with someone at a bar and I hit them or they hit me or something, right? This is assault. If you run up behind somebody and push them to the ground, like you're causing direct harm to them, that isn't a result of, something that would be done in the ordinary course of business. That's the easy way of explaining it without kind of getting into the law school definition, which I rarely deal with because I don't deal with intentional torts. I'm not a personal injury attorney. There you go. Intentional torts are usually the purview of personal injury attorneys. Some of the rest of us deal with just kind of the business matters. Okay, entity formation, steps. File your formation documents with the state of Texas. That's step number 1. Step number 2, you file your employer identification number with the IRS. Your formation documents with the check to the IRS are what will cost you, with a check to the Secretary of State, that's what will cost you in the beginning if you're just going to file those yourself. The EINs are free. Do not let anyone tell you otherwise. They are filed online through the IRS, and it takes less than 15 minutes to take care of that. All right. You can absolutely do that yourself. Your attorney just will, bill you for time and whatnot, expertise, making sure it's done right. But after that, you then want to create your entity agreements. I'm a little over time on this. Okay. So the reason you do this, the reason I put this in here is because EINs, or I have heard so many people say things like, oh, well, if you just file your EIN, you have a business. No, you don't. Okay. Well, all you have to do is just file an EIN and a DBA with the words LLC at the end of it. This is also not true. Okay. All of those are sole proprietorships, and I, the litigator, will go straight through them and find your personal assets if I have to. All right. Next up. Agreements. Now, I'm really hoping that I'm not going to embarrass myself here. You know, I highly respect the transactional attorney next to me, so take her word for it. But this is my perspective on it. Okay, so in the beginning, you've got a couple of different company agreements. They all have different names, and these are things that your attorneys kind of insist on. You know, we're sticklers about words and whatnot, but your company agreements are basically the documents that are a relation, or excuse me, your company agreements are contracts between each of the owners of the company and the business itself. Okay, so your company agreements are the things that will outline your rights, roles, and responsibilities with regard to the company. These are very important because whenever it comes time, whenever one partner manages to make the other partner mad, we need to know. Yes, I do handle nonprofits. Whenever one partner makes the other partner mad, no matter what business litigator you go to, the first question they are going to ask you is, what does your company agreement say? Is it a partnership agreement? If it's an operating agreement, what does your agreement say? And so whenever you're creating a company with someone else, you want to make sure that your company agreement specifically outlines the things that I have right here. Ownership percentages, your rights and responsibilities, how the owners are getting paid, procedures for what happens during death, divorce, dissolution, and disability. I think I got them all, Jessica. The next thing that your company agreement is going to talk about is the decision making. How are decisions made? Is one person having sole decision, just to use the cookie example, is one person having sole decision making authority with regard to the sales of the product and the other person having sole decision making authority with regard to the inventory? Do y'all share decision making? Who can buy what under certain amounts? How y'all have to make decisions over other amounts? So on and so forth. Anything that can be agreed upon or you think may be an issue, put that in your company agreement. Your lawyer will help with this. All right, next up, contracts. Be specific in your contracts, please. Okay, a basic contract is an offer, acceptance, and consideration. All right, now this means that something has to be offered, something gets, put back, or excuse me, something is offered, both sides are exchanging something that each other wants, and you put it down on a piece of paper, both people sign it or indicate some sort of acceptance. Acceptance can come in the form of each person just doing what it is they're supposed to be doing. We can construe that as acceptance, and any loose agreements from text messages to smoke signals, as long as we have copies of them, we can make those, we can enforce those in court, right? So you want to write it down. All right, you want to be specific. You want to measure performance. And again, anything legal can be agreed to. Now, a lot of the agreements that I've seen that I've fought over are very ambiguous. Heartache starts to happen when your agreement is ambiguous. So for instance, a lot of y'all are either going to engage with a marketer at some point in time during your business life, or you are a marketer and you plan on engaging with someone else. So let me use the marketing one as an example. All right. Whenever you engage with marketers, you need deliverables, okay? If I'm telling you to increase my social media presence and I'm telling you to, and I'm hiring you to increase my advertising, and I want all sorts of things, I need to delineate exactly what it is those are, okay? So when I say I want to increase my social media presence, that may mean I've got 1,000 followers right now. I'm paying you $3,000 so that you can go get me 3,000 more. By the end of our contract, I want 3,000 additional followers, and I'm going to pay you, or we're going to be able to measure this in milestones. So it's not just, oh, we'll increase your social media presence. What does that mean? Be specific, because if you are not specific, that can be construed against you. It's an ambiguity, so then you're fighting about it, then you're paying my bill, and it hurts. Don't do that. Be specific, write it down. Use plain language too. All right, I think we got funding here. Okay, this one is a topic that usually comes up in several questions that I get. And it involves access to capital. Okay, so a lot of Startup Week, you will see just a large number of venture capitalists. There's a lot of money that's going around, a lot of it. And you're wondering, how on earth is it that I can get access to some of that capital? Well, Because a lot of the VCs are looking for established companies, there's also been some shift in the industry to my perspective. She may have a different perspective as she deals with those deals a lot of the times. But from where I sit, there's been kind of a movement, or there's been a movement towards VCs offering money to companies who are able to achieve traction under their own power. Now, what does that mean? That means that in the beginning, you're bootstrapping yourself. You are, using your credit card. You're trying to figure out like, okay, well, how much of my savings can I put into it? Well, there are these wonderful little companies that we call CDFIs, CDCs, and CDEs, Community Development Financial Institutions, Community Development Companies, and Community Development Enterprises. All right, as well as the SBA itself. Okay, there are several different ways to get through this. I'm just going to kind of blow through it really quick. But what they do is they offer micro loans. Okay, micro loans, smaller loans that are kind of bisected up. So let's say that again you're running a bakery, right? You need $25,000 to really get off the ground. Well, Lyft Fund, People Fund, several of the other CDFIs, they're gonna break everything down into kind of milestones. And they're gonna say, okay, well, how much do you need to get your building? How much do you need to get your equipment? How much do you need to sell that first cookie? Okay, let's get you that. And then after you've, reached X number of sales or reached X amount of money, then we're going to extend you, more funds to increase, the reach of your business, increase your capacity, so on and so forth. This offers two levels of protection. The first level of protection is that, number one, because those types of funds are taking personal guarantees, you're protected because you're not taking $25,000 and then putting it into something that then doesn't work out the way you wanted to. And now you're on the hook for that entire amount. It kind of protects your downside liability, but also it doesn't overextend the lender itself because there's a pool that they draw from. But we won't go into that either. But in order to get money from them, you need to have several things. You need to have your financials in order. You need to have your you need to have past and current financials in order. You need to have customers. You need to have, basically all the data around your business, like how your growth model is working and everything else. You should also have a business plan. All right. What are your planned uses of capital? What are your milestones? What do you hope to achieve with each subsequent disbursement of funds? And with that, I will leave you with the whole idea that nothing in life is free. There's no such thing as a free lunch. So, you can try VC, but even VCs want their money back at some point in time. They will get their money before you do. All right. I did that all in 23 minutes. Questions, comments, and concerns.
Man, Aaron is just flying. He trained for this, I think, or else he'd be out of breath. Okay. I think I've been trying to answer questions as they pop up just because I wasn't sure if we were going to have questions, but it looks, or time for questions. So there's a question, why do you think VCs will get their money first? Do you want to answer
because
that?
VCs always get their money first. Are you joking? Read the contracts.
Yeah, most fundraising, most investment contracts give investors a preferential right to assets or money in the event of liquidation, company failure, or a lot of other situations. So generally, investor money is always the first out.
Yep. Here's a question. If you own a business under a sole proprietorship and want to convert it to an LLC, is that a good idea? So let me correct some of your language here. That's not a conversion. You will just start your LLC. Like you will file the LLC paperwork and bam, there you go. If you've already got an EIN, technically you can use the EIN for the LLC too. Not really the most advisable thing, but it's possible if you want. But so yeah, all you have to do is just pay the filing fee, pay your attorney, pay LegalZoom. We don't advise LegalZoom, but pay someone or just pay the state directly and you've got your LLC going.
I know Mercury Hall asked a question about amending dates for legal counsel contracts. I'm not 100% sure that I understand that question.
I think I will take a shot at that. Okay. So if you've got a contract with your legal counsel for payment at a later date, but there's no time limit set, is it really simple to go back and include a date, or is it the intent of the legal counsel to not have an ending date? So if you are unclear, you need to be clear. Okay. If you cannot unilaterally modify a contract. So you have to go back to your legal counsel for whatever reason you went to them in the first place, whatever reason y'all signed the contract, and you need to ask them, hey, is there an expiration date on this? And if there is not an expiration date on it, can we put one on there? If that is not, something that the lawyer wants, and again, I have no idea what the actual scenario is, but if it's like a contingency case that just hasn't settled yet, well, there's a likelihood that the lawyer's interest needs to stay open for as long as the case goes on, even if it's in someone's hands. So depending on the situation, you may or may not be able to do that, but you won't be able to do it yourself. You have to go ask that person for that, and then y'all are gonna have a conversation.
Yeah, generally if it's an like a general counsel arrangement, so it's someone that you're relying on for kind of day-to-day operational information, then that contract may not have an end date because it's just kind of open-ended based on y'all's ongoing relationship and their ongoing advising to you. Is it better to start a new LLC under a different name and add the sole proprietorship under the LLC? I think, and this is a situation that people get confused about a lot. Aaron, do you want to address? I
will.
Confirming what a sole proprietorship is.
A sole proprietorship doesn't exist. Yeah. Like, it's you interacting with the public. Like, it's not a thing.
Yeah,
okay?
I think sometimes people also get confused because they will say that they filed an assumed name certificate. So maybe clarifying what the role and purpose of an assumed name certificate is would be helpful, because sometimes I think people refer to that as a sole proprietorship.
So an assumed name certificate basically just kind of reserves a name, and it allows you to basically operate under that name. So if I've got, let's just say, Aaron's Law Office, all right, if I filed an assumed name under Aaron's Law Office, all that means is that whenever somebody else goes to register their business, they can't take that because that name has already been reserved. It's like, how do I put it? It's like an umbrella in the rain. Okay, like the umbrella is going to protect you, not really protect you, but it's just kind of, it's going to keep everyone else kind of away because the water's shedding away from you, but it doesn't actually offer you any full protection. But
DBA and an assumed name are the same thing. Assumed name is just putting people on notice of who they're doing business with, so that I know when I sign a contract with Aaron that I'm really doing business with Aaron's law firm.
But yes, somebody said why I don't recommend LegalZoom. So for starters, I will, LegalZoom has a time and a place. LegalZoom provided access to a lot of legal stuff that was previously solely held by attorneys. So I can't knock on LegalZoom completely. However, what LegalZoom does not do is they're not able to give you legal advice. And so when you come to me and you say, okay, I have this, if you have an interesting entity structure, if you have multiple people trying to do this one thing and you go to LegalZoom thinking, okay, well, I can just create an LLC, it's entirely possible that you didn't actually need an LLC. Maybe you need a limited partnership. If you thought that you were going to be taxed one way and it turns out that you were going to be taxed a different one, the value in having an actual person there that can give you advice, whether or not they offer a free consult, is to just kind of listen to your situation and then provide that level of expertise. Like, okay, you need A, B, C, D, and E. You don't have to worry about F, G, H, I, and J, or you need all of it, whereas you were going to, only get a part of it beforehand. So it's just the value in having an expert in your corner. All right. Is a B Corp better than having an S Corp and a nonprofit? Depends on what you mean by a B Corp, okay? And I don't know if this session is going to kick us out at some point in time soon, but I'll just keep going until it does. All right. A B Corp, there's two types of B Corps. Technically, there's only one. One, the actual B Corp that you may be thinking of is a designation that is owned by a private company. So you have to apply to that company to be certified as a B Corp, okay? And then they've got their requirements and whatnot. It's just like getting any other designation, minority owned, women business owned, historically underutilized business. It's another designation just like that. However, what you may be referring to is what's commonly referred to as a public benefit corporation. Here's the difference between a public benefit corporation and an S corporation. All right. You whenever you file that company, you are agreeing to operate that company in the best interest of the shareholders, okay? Usually if you're an owner, you're a shareholder. Or if you have additional outside investors, you are saying we are going to operate this company in your best interest. We are trying to return capital to you, okay? Whenever you create that S Corp and that money comes in, that profit belongs to the shareholders, all right? With some nuances, of course, but that profit basically belongs to the shareholders. So if you decide that you're going to, if you decide as the owner of the company that you're going to engage in some sort of charitable activity, then that charitable activity is wonderful and great, but it has to only it has to have very limited impact on the shareholders themselves, because if it doesn't, what the shareholders can do is sue you for mismanagement of the money. So let's use an example here. You create an S Corp, you decide that you want to go out and save the trees. Well, you take 30% of the profit that comes in and you go out and you invest in forest. The shareholders are going to sue you for mismanagement of that money, all right? Because that money is theirs. They did not tell you to go spend 30% of their profits saving the trees. With a public benefit corporation, all you're doing is basically saying, I have a for-profit corporation, but this for-profit corporation has a charitable purpose. It is our goal to take 30% of our net profits and use it to save the trees. So when your investors and your shareholders sign on to that and you use 30% of their money, your profits, to go save the trees, they can't sue you for that because they knew that in the beginning. So that's the difference between a public benefit corporation and a regular S Corp or corporation. Jessica, did I get that right?
Yes, that's a good explanation. What if they approve it during a board meeting or a shareholders meeting?
If they want to approve it, that's fine. That adds an extra layer of complexity to it. So if everyone is aligned in their vision, then you can do it that way. That's not going to be a problem at all. But it's this basically it's do you want to ask for forgiveness or permission type of thing. On if you have an S Corp and you want to go use 30% of your money to save the trees, you're asking for permission. All right. If you're a public benefit corporation and you are using 30% of your money to go save the trees, you apologize to the shareholders after the fact, but say, hey, this is what you signed up for. Sole proprietorship is not incorporating an entity, right? Correct. Yeah.
I think the last question that I didn't think was addressed is your views on LegalShield.
Oh, LegalShield keeps hunting me down. Like LegalShield loves me, but I refuse to sign up with them. So again, I'm not going to, just completely I'm going to say something good about them before I get into why I won't sign up. LegalShield provides, again, a basic level of access to a service that is ordinarily considered pretty pricey. For instance, my litigation price is generally $350 an hour, even though there's a lot of things that I flat fee, right? If you're a small company, and you've got a case that you're defending in small claims court, maybe you don't want to spend $1,500 to start your case, right? Maybe you don't want to spend $1,000. LegalShield will provide you with an attorney who will do the most basic necessary to try and keep that, to try and resolve the issue. Okay, yeah, exactly, to resolve the claim, okay? The problem that I have with LegalShield on the back end is that in complex litigation, and by complex litigation, I mean it could be anything from, a breach of contract with a $25,000 damage model and ongoing harm, that requires more than what LegalShield is willing to pay their attorneys. So you get what you pay for. It is what it is. Not going to bother anybody who signs up for that. But that's for the type of person or generally you get attorneys who sign up for that want volume practice. Like they want that extra business and they're willing to do it for, $80 to $100 an hour. And there's absolutely nothing wrong with that. It's just not the way I run my practice. I tend to I get involved in my client stuff. Like when they come to me, that's my matter. That's my problem. Like an attack against my clients is an attack against me personally. So I take all of that very personally. I'm compensated for it. The LegalShield type of thing, they want to just run you through a mill. Sorry, LegalShield. Are there benefits to shifting from an S corp to a public benefit corp? That depends on what you're trying to do. If you have a clear charitable purpose that a disproportionate percentage of your revenue is going to go to, whether or not anyone likes it or approves of it, probably better to go with the public benefit corporation. If that's not a real thing for you, S corp, if you are already an S corp, then S corp is fine. I am not your attorney. That is not meant to be legal advice. If you want legal advice, feel free to. Do I have it? Is it up here? No, darn it. Okay. Apparently I didn't.
The one slide you forgot.
Right? How did I do that? Okay. But yeah, so yeah, talk to your attorney about that. Like without knowing the specifics of the situation, I can't tell you whether or not that would be a good idea outside of just the disproportionate, revenue sharing. If that was something that you were worried about in the beginning, it's something that you may want to consider. But if that's not really a concern, go ahead and stay where you are.
And with that, I am going to thank Aaron so much for sharing your expertise and your insight and for your speed responses to this lightning round questions. We sincerely appreciate you. Definitely find Aaron on LinkedIn, on social media. He posts a lot of helpful stuff. If you have some time and you want to stick around, in about 5 to 10 minutes, we'll be starting our intellectual property basics session. This will also be really, really helpful, and we will be around. So find Aaron if you need to talk to him. I hope to see you in the intellectual property basics session. And thank you again, Aaron. We truly appreciate you.
Thank you, Jessica, for the invite.
Yeah. Bye, y'all.
Hey, Aaron, I'm Zoom bombing you, or hop-in bombing you.
I see that. I don't know what's left. Like, I thought that I was going to get kicked out of this, but apparently that's not the case. Your questions were hilarious, by the way.
Oh, thanks.
At least the ones that I caught while I was busy running on.
I am truly fun to be around. So I just wanted to pop in and say thank you, and then we probably do need to shut it down because I think that enables the organizers to start the next session.
All right, let me leave this here meeting then.
I'm going to connect with you on LinkedIn. You are a rock star. Thank you for coming.
All right, later.
Bye.